All right, so it is 10 o'clock, so we will get started. So first of all, thank you everyone for being here today. This is the session for Social Media Law, Understanding Social Media, the First Amendment, and the Brown Act. I'm Christine Cordone. I'm the City Clerk and Communications Director for the City of Westminster. Definitely excited to be here. I know it's different than how we've met before, but certainly we're still getting things done and rocking it as clerks. So today's session will end at noon. We don't have any scheduled breaks, so it is a full 2 hour. It is a 2-hour session. But before we get started, we just want to take this time to acknowledge and thank some of our sponsors. This conference was made possible in large part due to their generosity. So at this time, we have 2 brief videos that we want to share featuring our presidential sponsors, Netfile and Granicus. So please play the videos.
Number 1 for city clerks. Over 90% of all cities that use an electronic filing system use NetFile. That's over 120 cities. Only NetFile offers third-party campaign finance software used by over 70% of Secretary of State filers. And NetFile offers one-of-a-kind features like RSS feeds, independent expenditure searches, and free one-on-one NetFile campaign filer application training. Why is NetFile number 1 for Form 700 filings? Over 72% of FPPC-approved e-filing cities choose NetFile. And our software comes with all features, no upsells. Unlike the competition, we provide unlimited training and support at no additional cost ever. And only NetFile offers advanced public search features, mobile apps through the Apple Store and Google Play, and advanced validation virtually eliminating amendments. Last but not least, service and support are our specialties. Visit us on the web at www.netfile.com or contact Tom Diebert at sales@netfile.com.
As a public servant, you work hard to deliver vital services to citizens while complying with regulations. That's not easy. You're plagued by outdated systems and drowning in paper-based processes. As your organization's workload grows, it's hard to keep up. Imagine a world where you become the hero of the meeting process. With Granicus, you can do just that. We make it easier to prepare, run, and follow up on civic meetings. Granicus enables you to balance last-minute agenda changes, giving you the power to keep your citizens informed. We have one goal: to turn you into the hero. We streamline your tasks while saving you time to focus. Our platform is purpose-built for governments and trusted by over 4,000 organizations across the globe, so you get easy-to-use tools that meet your needs. We ensure you never have to print an agenda again. No more wasted paper. No more battling the printer. We make it easy to get them approved. We help you automatically create minutes, share them, and drive your citizens to action, all while getting the job done quickly and easily. When you partner with Granicus, everything's possible. Reach out to us today, and we'll show you how Granicus can make you the hero of your department.
Thanks so much for that. So just as a reminder, this session is eligible for half a CMC or MMC point. Session materials and the learning assessment for this session can be found on the conference website, which is www.clerksrock.com, because we do rock, and it's under the course description. So certificates of attendance will be provided after the conference. If you have an urgent need for the certificate, just please contact Anthony. There will be a link provided at the end of this session as well for you to fill out that assessment. And of course, the assessment is required in order for you to get credit, and you do have to stay for the duration of this session. With that being said, I would like to introduce our speakers for today. So we have Christine Wood. Christine N. Wood leads Best to Best and Krieger LLP's ARC Advanced Record Center, which provides comprehensive and cost-effective support for records-related matters, including California Public Records Act request processing. An attorney and certified e-discovery specialist, Christine is also an experienced and sought-after trainer and presenter with an easy and conversational style that clients appreciate. She previously worked as Assistant General Counsel at LA Unified School District. Our second speaker is Hong Dao Nguyen, and she assists public clients in transactional and litigation matters concerning the municipal government with a focus on land use and public records laws. A partner in the municipal law practice group of Best and Krieger LLP, she serves as Assistant City Attorney for the city of Stanton, Aliso Viejo, and Lake Forest, and as Deputy City Attorney for the city of San Clemente. She also serves in BB&K's ARC Advanced Records Center, which provides comprehensive and cost-effective support for records-related matters, including the California Records Act request processing. And basically, the session, the purpose of this course is to provide municipal clerks an overview of the intricacies of how social media by government entities relate to various state and federal laws, specifically the First Amendment of the United States and the Brown Act, with emphasis on AB 992, which went into effect January 1st, 2021. And without further ado, Christine and Hong Dao.
Thank you, Christine. I'm going to, the host has disabled participant screen sharing. Would you be able, Christine, to share? Oh, there it is.
Okay.
A quick host, thank you. Okay. There we go. And I don't see Hong Dao, but I'm assuming she's there.
I am here.
Okay, yeah. There you go.
Can you hear me, Christine?
I can hear you fine.
Okay, great. Well, welcome everyone. Thank you so much for joining us today. It is certainly our pleasure to be here speaking at the City Clerks Association. I won't speak for Christine. Both of us do a fair amount of speaking gigs, and this is personally one of my favorite groups to be with. And so a few housekeeping items. We want this to be as interactive as possible. So if you have a question, I think the best way is just to put it in the chat, and Christine or I will monitor it and answer as we go along. So please don't hesitate to do that. If you can go on to the next slide, Christine. Christine, do I have access to the slides, or can you click to the next one? Ah, there we go. Okay, so thank you to the other Christine for the introduction. I'm Hong Dao Nguyen, and I am, yes, I'm city attorney. Some of my bio has changed just a little bit. I'm now serving as city attorney for the city of Artesia and the city of Stanton. I also work very closely with Lake Forest, Aliso Viejo. And in my previous job, I was a reporter in the Bay Area for the San Jose Mercury News. I covered a little bit of Gilroy and Morgan Hill, worked a little bit out of the Palo Alto office in East Palo Alto. I know there's city clerks from all across the state on this, so just wanted to note that I've kind of been up and down the state. As a reporter for the San Jose Mercury News, I covered local government and police issues. And so I come into this with a background in, looking to keep local governments accountable and seeking information for news purposes, but then also being on the other side now and wanting to, lawfully protect cities and jurisdictions within the legal confines, as well as being transparent as possible with the public when it comes to the Public Records Act, Brown Act, and so on and so forth. So I know that Christine has a newspaper background too. If Christine, you want to go ahead and give a little thoughts on your background.
Sure, thank you, Hong Dao. It's so funny. There's so many hi Christines in the chat, and so I hope no one's saying hi to me. There's so many Christines in the session, but I'm just going to say hi at one time to all of our friendly clerks and clients, BBK clients and ARC clients. It's really, as Hong Dao mentioned, it's really good to be with you guys today. This is always definitely one of my most favorite presentations during the year, because I just think you guys get it and have the most practical, in-depth questions, and you challenge us to really think about these things practically. So Hung Dao and I really enjoy this presentation. I think, as Hung Dao mentioned, I do have a background in the media. Prior to joining the legal profession, I worked as a strategic marketing professional for newspapers throughout the country. I did a variety of work for different newspaper companies, but I'm also third generation in my family to make a career in the newspaper business. And so I've grown up being around journalists and newspaper people who understand the importance of sunshine laws and transparency in government. And, having been an assistant general counsel to LA Unified, which is the second largest school district in the country, I've had a lot of experience answering public records requests as in-house counsel. So I do feel for you, even though I have grown to love the PRA. I know what a pain it can be. And I do know that gadflies have become increasingly aggressive and complex and just complicated in terms of their requests. And so I remember before I became a lawyer, I was a paralegal, and we would do PRA requests all the time. And I felt like then, the people were just asking for PTA notes and really simple things. And now it's gotten, because so many things are already online or maintained electronically, their requests have gotten so much more complicated, which is why Best and Krieger created the Advanced Records Center, just to try and provide you a different depth of support and knowledge as we handle requests for public records, particularly electronic records. And so that's my background and the perspective that I bring to the work that I do for our municipal clients every day. And so again, we're just really happy to be here today to talk to you about social media and the First Amendment and all of the other issues. Hung Dao?
Great. And if you can go to the next slide, Christine. Thank you very much. All right, so for longtime clerks, you might have heard Christine and I talk about some of these issues that's listed here: social media overview, the First Amendment, Public Records Act. We've kind of really been up to our knees in these topics over the years. And so what we wanted to present today was that we wanted to kind of put it all together, right? And the truly new material is the Brown Act slides, which relate to AB 992. But as we thought about AB 992, which allows public officials like city council members now to, dialogue with members of the public on social media, that immediately raised issues of the First Amendment, Public Records Act, and retention. So through this presentation, we wanted to just kind of show you all the pieces and how one affects the other. And so we will go through social media overview, Brown Act, First Amendment, and Public Records Act. And one of the things Christine and I talked about before, as we were putting together these slides, are even though things like the San Jose case came out in 2017, a few years ago, we're still fielding questions on these topics. So we see that it's still timely and questions are still arising. I mentioned that go ahead, please put your questions in the chat and we'll get to them. The other thing is throughout these slides, we're going to come up with hypos just to keep it a little interactive. When there's a hypo, please put your answer in the chat box. And we have 5 Amazon gift cards to give out. So we'll put everyone's name in a raffle and then select 5. I think they're $10 Amazon gift cards. So if you want to participate, please do when the raffles come up. So the first set of slides is the social media overview, which I will send over to Christine.
Thanks, Hung Dao. So I think it's really important to take a minute as clerks to just talk a little bit about social media. We've done this presentation, as Hung Dao mentioned, quite a few times, but I think it's important just to remember kind of social media, both in a technical context, in a, kind of social, societal context, but also in a legal context, right? So I'm going to do, again, a brief social media overview with some updates with 2020 data, which I think is kind of interesting because the social media interaction, obviously, as everything in our life changed last year, social media and our interaction with social media changed. I love this slide, though, because it just kind of reminds us that there's some, every social media platform has something that it's about, something that it means to do, right? So, whether you're on LinkedIn looking for a job, or you're on YouTube trying to get viewers and get people to watch you, or you're on, Pinterest trying to show off a new recipe. There's always some social media platform that's designed just for you. Unfortunately, as public officials and city clerks, you guys have to think about how to be present in so many of these spaces, right? Because that's where your constituents are. And so I know many of you are, you already maintain some form of social media platforms. But in addition to the normal ones that you already maintain, like Facebook and probably an Instagram or a Twitter account, you're probably also on Nextdoor now, right? You're everywhere because that's where your constituents seem to hang out. So just as a reminder, when we talk about social media, we're using a term that reflects interactivity. It relates to any kind of a network, internet-based network that allows for interactive dialogue. That can include the social networking apps like Facebook, YouTube, Pinterest that I talked about, LinkedIn, or messaging apps like Snapchat, Messenger, Skype, and WhatsApp. Those are all kind of interactive places for engagement. It's not the same thing as, a website, your static website. Usually your city websites are not interactive, or your municipal websites. So that's not what we're referring to when we talk about social media. We're talking about a place where there's interactivity. It's important to recognize that YouTube continues to be the most widely used online platform for US adults. Pew continues to show Facebook and YouTube as the two largest platforms. YouTube has gotten, it's gotten so much more robust, I think, than we originally thought of it as. Now you have YouTube videos and YouTube TV, and there's just so much there that and a great interactive way to kind of engage with people. And Facebook, the same thing. It's still very, very high in terms of adult usage in the United States. But last year, what we really saw was that some of the other platforms were adding huge figures, huge numbers of users in 2020. So as the quarantine, kept us all at home and sheltering in place with our families, we were looking for ways to escape, obviously. And so one of the ways we started escaping was through these social media platforms. And so you see that Facebook in 2020, in the third quarter of 2020, added 39 million monthly active users, where Twitter added 1 million and Pinterest added 26 million, right? Because remember, at the beginning, we were all online cooking and baking. And so, we were all looking for ways to kind of interact and find out what other people were doing. Another phenomenon that became a really big deal last year was TikTok, the app that comes, that I want to say that young people use it. This so dates me. I never thought I'd be that old person, but the app that younger people use to post videos. But I mean, they also are posting videos of cooking and recipes, and when you look at the new users compared to Instagram, TikTok is just flying by Instagram in terms of users. And so in the quarter one, you saw such a huge increase in the number of users using TikTok versus Instagram. In some ways, it's a lot like Instagram, where it can just become a time suck, right? I see Jahan I'm sorry, Ferd is saying that he loves watching TikTok videos. You could just get in there and just continue to scroll and find, or I don't know if you scroll this way or you scroll up. Clearly I don't use it, but however it does it, you can just, you lose yourself in those. And I think it's a great way to realize that, again, your constituents are going to be somewhere else, right? I don't know, to answer the question Maria has, if any municipalities have started a TikTok account, but I think people are doing all kinds of different things, right? As some of you may know, even I this year, thanks to Stephanie, have did a different type of promotional video for BB&K and ARC than we have done before. I think everyone looking to engage an audience needs to think about how to do things differently to make sure you stay engaged and connected to the audience. So if you haven't as a municipality, I wouldn't necessarily rule it out. And then from a legal perspective, I just want to remind you of some of the things our Supreme Court has said about social media. So our United States Supreme Court in 2017 decided the Packingham case. And in the Packingham case, they really put into perspective how our courts were going to start to think about the social media as a space, a legal space, right? This is really starts to become the foundation for all the other cases that Hung Dao and I are going to talk about today. But in the Packingham case, I'll give you the background quickly of the facts of the case. Packingham was a registered sex offender in the state of North Carolina, and he had been banned from certain social media platforms because he was a registered sex offender. And in these platforms, there were active, minors who were users. And so the platform felt like, to be safe and to protect the minors who were using their platform, they were removing and banning people who were registered sex offenders. And Packingham filed a suit to say that he should be able to access these social media sites. And in the end, the Supreme Court found in his favor and said that social media is really considered the modern public square. So when you think about a park or, a gathering place, that what used to be considered the public square, this is the modern public square: Facebook, YouTube, Twitter. It represents a revolutionary space for civic discourse. It's how people are able to engage their municipality very often, or even their elected officials, and we'll talk about that in a moment as well. It provides the principal sources for current events, right? How do you find out what's going on? I actually personally am in the middle of a really big kind of project personally and professionally, and so I have a lot going on. And so I'm one of those people who just recently deactivated all my social media accounts. And what I realized is that I don't know anything that's going on. Like, all of my friends are like, "Did you see this?" They're texting me, and I'm like, "No, I don't see anything anymore. I have no idea what's going on." Because a lot of people, even younger than me, are getting their news, their events. They're getting all of their information through social media. And they've also, Packingham, the case that the Supreme Court said that it provides the most important places for the exchange of views today. And I think that this is a great case to lay the groundwork for why it's so important for not just for us to be in those places as municipalities, but also for us to understand what duties come from us being in those places. And so with that overview of social media, the question just remains, how then, as a public agency, do you engage in that space and do it within the parameters of the existing law and with best practices? And so I'm going to turn it over to Hung Dao, who's going to tell you a little bit about how our California legislature thinks you should do that through AB 992. Hung Dao?
All right. Thank you, Christine, for that overview. I'm going to get into social media and the Brown Act. This group knows the Brown Act inside and out, I'm sure. As a kind of 10,000 foot look, it is the open meetings law that requires that when a quorum of the city council or commissioners, basically your legislative bodies, meet to quote unquote deliberate, discuss, or take action on a matter in the city's subject matter jurisdiction, then it has to be at a noticed agendized meeting. And you know, I used to give, or I give sometimes now, AB 1234 trainings. Those are the ethics trainings, and they typically cover the Public Records Act, Brown Act, you know, FPPC type of regulations. And whenever I used to get into the Brown Act, you know, questions used to arise of, well, can we talk on social media? Can public officials talk on social media together? And our standard answer was, look, the Brown Act doesn't address that, but as a best practice, you know, you probably don't want to do that, and it's probably a violation, but it's not explicitly in the Brown Act, right? That has changed. AB 992 is the new Brown Act law, and now it explicitly addresses public officials' use of social media. It came into effect on January 1st, 2021. So we're already kind of into the new law, and it addresses when a public official can use social media for public business, and when he or she cannot use social media communications, or what is discouraged, right? So the legislative intent here was to kind of encourage public officials to use social media to interact with the public and constituents. And I feel like, you know, public officials, city council members, commissioners are kind of all over the board when it comes to social media. We have some city council members who are super, super engaged and, you know, want to kind of talk about everything about city business on social media. And then I have other folks who just don't want to touch it with a pole, right? So we're all over the spectrum here. Next slide, Christine. All right. So the AB 992, this is how it applies. So it applies to internet-based social media platforms that are free of charge and open and accessible to the public. There's a whole long definition for internet-based social media platforms within AB 992. So that is just kind of an overview of it. What we know it to be is it'll apply to Facebook, for example, because that's an internet-based social media platform that's open and accessible to the public. Other portions of the definition provides that, you know, again, it's free of charge. You don't need approval by any social media platform or person other than the platform to be able to use it. And so there are definitions for these terms. Next slide, please. And again, just kind of going on to what does it apply to. Other platforms may include Snapchat, Instagram, Twitter. I am not a huge social media person, and so, you know, sometimes we get questions on, does it apply to this platform or that platform? I don't know it exclusively, and the legislation doesn't really specify any type of social media platform specifically, right? Another note on it is, you know, what are we talking about here? We're talking about comments, retweets, likes, dislikes, emojis, and we'll kind of get into the ins and outs of how that works. I have a couple of questions. It does not replace. Okay, so Christine notes that it doesn't replace the Brown Act. It just gives additional laws that govern the use of social media by elected officials. So yeah, that's right. It's just another portion of the Brown Act. It's I think in like 59562.2, it's under the definitions of meetings. Don't quote me on that statute, but it's in the section that defines what is a meeting, right? All right, next slide, please. Okay, so let's get into the actual, you know, meat of AB 992 with the next slide. What is permitted? AB 992, like I said, is a statute that encourages public officials to use social media. I think having read the legislative history, legislature was kind of nervous or concerned that public officials were not engaging in social media, and they wanted to encourage more use of social media by public officials to interact with the public. So now what is specifically permitted is a member of a legislative body. And so here a city council member or a planning commissioner is expressly now allowed to communicate with the public using social media in order to talk to them about subject items within the city's subject matter jurisdiction, right? I've gotten questions before on what is something under the subject matter jurisdiction of an agency, such as city business. The Brown Act doesn't define what subject matter jurisdiction is, but it's what you would usually expect. It would include things that have been on past agendas, that are on current agendas and future agendas, budget items, city events. And so it's pretty broad. Next slide, please. And what is specifically permitted is that public officials are allowed to solicit information from the public. They're allowed to ask questions. They're allowed to give information to members of the public. And prohibited, so I mean, just going back to permitted real quick. So let's say a council member posts on his personal Facebook page, quote, "The city council recently approved a vaccine center within the city. Please contact the city if you can volunteer at the site next week." That would be a permitted use of social media by a public official because he or she is, giving information to members of the public. But what is prohibited is there's two major prohibitions under AB 992. One is what you would expect, is a majority of members of the legislative body cannot use that social media platform to discuss agency business. So let's pause there real quick. This is what you would expect, right? So let's say you have a 5-member city council. We would say, if you guys get together and have lunch outside of a meeting and discuss city business, that's a Brown Act violation. If you use email and there's a quorum of city council members who, email about city business, that's a Brown Act violation. So now when you get on social media and a council member posts about something and 2 council members, respond through a comment and through an emoji saying thumbs up or, heart emoji, that is now a violation because you have a quorum of council members, for example, discussing city business. People have asked me, well, is using an emoji really a communication? And AB 992 explicitly notes that even using an emoji, a digital icon to express a reaction is a communication, right? So that is a kind of a natural extension of the Brown Act, that a quorum of council members or commissioners who are using social media is now a Brown Act violation. The next prohibition is kind of a little bit more surprising, and I've gotten more questions on it. The second prohibition provides that a member of a legislative body cannot directly respond to a communication of another member of that same legislative body if it's about city business and if it's on social media. So again, practically that looks like, council member A responding directly to council member B about a post that is about city business. So we're going to get into some examples of that, but that's a little bit of the different, more stricter prohibition under AB 992. Next slide, Christine. Okay. So I want to kind of pause on that direct response issue. And it's a little bit odd because under the Brown Act, we know that, if 2 council members or 2 commissioners talk about an item of city business, and that's either through lunch or through an email or through a phone call, that's typically not a violation of the Brown Act. The Brown Act, applies to a quorum. So it's it's been unclear to us, and we've read the legislative history, and we never really understood why AB 992 has stricter prohibitions on social media contacts than in kind of the real world, the physical world, or email or text messages even. We kind of thought about this and said, well, you know, maybe because it's so public and you know, the legislature is trying to discourage that. We're not really sure, but I think the point that we want to make here is direct responses is a violation of the Brown Act, and we will get into a couple hypos later that kind of illustrate that. Okay, so next slide, please, Christine. All right, so this is the first hypo that I'm going to go through. And again, if you have a response to the hypo, please feel free to put it in the chat. Hypo number 1, next slide, Christine. So it's hypo number 1, is a local newspaper blogs about the city council's action to give permit parking to a large neighborhood. However, the newspaper has a paywall that comes up after 3 free articles, blocking readers from seeing the article unless they pay. Is that blog subject to AB 992 if individual council members want to chime in on the comments? All right, so again, the scenario is there's a local newspaper wants to blog on an item of that the city council is giving an action on giving permit parking. There's a paywall issue. Is the blog subject to AB 992? Okay, I see a ton of responses. Lots of no's. I see a couple responses. I'd say it's complicated. No, because it's paid. Maybe. So a lot of great responses. Thank you so much, everybody. All right, next slide, Christine. Okay, so the next slide is the answer. It's unclear, right? And here, again, AB 992's regulations apply to internet-based social media platforms that are open and accessible to the public. So open and accessible is defined as in the statute as members of the general public have the ability to access and participate free of charge in the social media platform without approval of the social media platform or a person other than the platform, including any forum and chat room, and cannot be blocked from doing so, except for when the media platform determines an individual violated its protocols or uses or rules, right? So that's a mouthful. You'll see that I highlighted the free of charge one, and a lot of folks said no, and I agree, right? If there's a paywall that comes up after 3 free articles, probably not your quintessential social media platform. You don't have that, for example, with Facebook. You don't have that with Twitter. No one's asking you to pay money on those platforms to use the platform. So probably not. So I think that's great. Got a lot of notes there. All right. So next slide, please. We're going to go on to the next hypo. And the second hypo is the Parks and Recreation Director posts on the city's website about the reopening of city parks, right? And, you know, a lot of California has moved into the orange tier, and here we are reopening city parks. But the director advises the public to continue to adhere to social distancing and wear masks. So one council member posts on the city's post. Without seeing the comment, council member B also comments on the same post. Has council member B violated the Brown Act under AB 992? So I'm going to pause here and let everyone respond. Okay, lots of responses, and I think you can see the chat too. So lots of no's. All right. Okay, great. Next slide, Christine. Okay, so again, we've got a city post now, and one council member responds to that city post, but so does another council member right afterwards. Okay. Here, you know, I'm going to lawyer it a little bit, and I'm going to say we need more facts, right? So did council member B intend to respond directly to council member A, or did council member B intend to directly respond to the post, right? I think the hypo noted that the council member B didn't know that council member A had responded and without checking the other comments. So what I mentioned is, until the law is clarified, a best practice is to have council members check to see if someone else has commented on a post before commenting or liking a city post. Or a council member could share that city post on his or her own page without running afoul of AB 992. And I think this is kind of a challenging thing because I at least use Facebook, right? And so I'm aware that, you know, when you get to so many comments, it starts to kind of umbrella them and hide them within, and you have to kind of expand it out in order to figure out. And so when I was talking to a council member, one of my council members, about this a while ago, and we were just kind of playing the hypotheticals, I said, yeah, you know, a best practice is to unhide all those comments to see who has commented. And just a note about this, let's say it's not even a violation, right? We know that every city has its gadflies. And when it comes to members of the public, and they might not understand the ins and outs of AB 992, it's very easy for them to say, hey, this is a violation, they're talking to each other. And so, you know, it's just a difficult spot that public agencies get into because, you know, even if it's not a technical violation, people will still try to cry foul on some of these issues. So I think, you know, one of the things we said was, hey, if you really want to comment on a city post, you know, an option is just to share it yourself and have that be your own post, because it gets kind of complicated with the comments and likes. Okay, so that was hypo number 2. Let's go on to hypo number 3. Christine, if you can go on to the next slide. Okay, hypo number 3. Council member C gives a thumbs up to council member D's post. And we're in a city here, right? So council member C gives a thumbs up to council member D's post, declaring that the local school district just opened for in-school learning. You can tell that I have the pandemic on my mind. So they're reopening schools and we've got a thumbs up. What do you think? Is this okay or not? I'll give everyone a note. Okay, I've got a lot of not okays. All right, Christine, can you go on to the next slide that gives an answer? Okay, so for me, a question is whether school reopenings is within the subject matter jurisdiction of the city. On one hand, we could say, you know, does the city really cover school reopenings? Who knows, right? But having said that, it's a factual question. I know a lot of cities, for example, provide school crossing guards to the local school district. So there is a close relationship between the city and school district. You know, some cities have passed resolutions or letters urging school districts to open. And so let's assume that it is within the subject matter jurisdiction of the city. And, you know, probably it is, right? Because they're so closely aligned. Then that thumbs up would be a violation of AB 992. But let's say the school reopening isn't in the subject matter jurisdiction, then there's no prohibition on members of the same legislative body commenting upon one another's personal posts. What I was talking about in the last slide is that, you know, you have the law and then you have public perception, right? I don't know if a typical member of the public would understand, hey, that is within the subject matter jurisdiction of the city, or that's not within the subject matter jurisdiction of the city. So that's kind of one of the things that just kind of happen in the background as well. But these are the type of questions that we would ask if, you know, this came up. You know, it's very technical. Is it in the subject matter jurisdiction? You know, what was the intent of the post, and you know, the intent of who was, you know, giving it a thumbs up. Okay. And then I have a couple of questions here. Okay, yeah, so here's a spin on the hypo. What about if the council has an education standing committee and these discussions are often reported during council meetings? Then it becomes city business, sort of. Yeah, I think that's great, you know, and that's why these become such a factual question. In Southern California, there was a recent letter, like a public comment letter that was sent to all of the cities, right, around here. At least, you know, I'm aware of about a half a dozen of them. And it was allegations of fraud that was occurring in that particular city, but it was sent out to, like, you know, up in LA down to San Diego. But it was about fraud in that particular city. And a question came up of, is that really within the subject matter jurisdiction of our city? Should we even allow this public comment to come out? And, you know, we roundtabled it and we decided that the issue of fraud in cities is so, not a big deal, but it is an important issue that, you know, we allowed the public comment to be heard. And so I think our position is that we generally interpret subject matter jurisdiction to be pretty broad and liberal and not, you know, narrowly. Okay, so next hypo number 4. So we've got council member E. We're moving up the alphabet now. Council member E writes a post urging residents to come to the next council meeting when a proposed 100-unit affordable housing development is on the agenda. These are very controversial type of projects. Affordable housing is a really hot topic. And so council member E tags council member F in the post. Is that okay? Is it okay if a council member writes a post about a city issue and tags a council member in a post? Is that all right? Okay, I have some yes, I have some no's. Christine, can you move on to the next slide, please? All right, the next slide is the answer to hypo number 4. And my answer is probably, this is probably fine. AB 992 prohibits public officials on the same legislative body from directly responding to another official's posted or shared communication on social media if it relates to agency business. Here, council member E isn't responding to council member F, but he's merely tagging that person, right? I think the problem, not a problem, but the delicacy of tagging is that when you tag someone, it kind of invites a person to respond, right? When you get tagged, you want to kind of give it a thumbs up or an acknowledgement that, oh, you tagged me, I saw that, right? But tagging in and of itself isn't a violation of AB 992, but it would be a violation if council member F then directly responds to that post by, you know, giving it a thumbs up or responding, right? So that's kind of the difficult thing with tagging. And then next slide, please. And thank you for all your responses on the hypos. We're going to have more hypos later on, but we'll just go into some FAQs on AB 992 that I've gotten from folks. Does AB 992 affect public officials texting or emailing each other? No, you know, AB 992 is exclusively for social media. It doesn't apply or call out texting or emailing. So the weird thing about it, right, is that public officials can still directly text each other if it's just the two of them, or email them if it's just the two of each other. But again, on social media, they can't have these direct responses. All right, next slide, please. The next slide relates to, let me get there. AB 92, does it have any new enforcement mechanisms? And it doesn't. I think I mentioned this earlier, but AB 992, the provision that was updated includes definitions of meetings, right? And so let's say a member of the public, a gadfly, is on the social media page and sees council members, you know, having a quorum, discussing city business, or directly responding to each other, it would be the same type of enforcement mechanisms where they would, you know, reach out to the city and say, you know, you guys have been violating the Brown Act and you need to stop. And if they don't stop, then they can sue. It's a little bit odd though, because, you know, a city is supposed to have the opportunity to kind of unwind an action and say, we're never going to do it again. And it's just, I think the best thing that could happen is we'd have to admonish the council members, don't do that again. So it's a little bit untested. One of the takeaways that we'll note later on, and that I'll just note right now, is AB 992 is so new. It only came out a few months ago. We don't have a lot of information on it, and so we're just still gathering kind of how to deal with it. All right, and that is the next slide with the takeaways, where again, AB 992. What I would do is, you know, inform the public officials of this new law. What we usually do is when we do our AB 1234 training, that's the ethics ones, that has to be given, I think, every couple of years, right? We add a couple of slides about AB 992 and say, hey, there's this new law about, you know, public and social media, public officials' use of social media. You should be aware of it. And let them know that, you know, while AB 992 is there to encourage you to collaborate with members of the public about public business, you should be aware of the prohibitions and kind of this more narrow, stricter interpretation of how you can communicate on social media. Right, so that is my slides on AB 992. I'm going to give these slides over to Christine to start off on social media and First Amendment.
Thanks, Hung Dao. Can you hear me? I feel like I've been quiet for so long. Hopefully you can hear me. So social media and the First Amendment really became an issue within the last 4 or 5 years, where people really started to think about how does social media and some of the things that Hung Dao talked about previously, when social media is being used by the government, how does it impact people's First Amendment rights? And there's been several cases in the last, I would say, 5 or 6 years that really start to address this issue. One of the first cases that we were aware of that we started to monitor very closely was the Davison v. Loudon case that involves a Facebook blocking. So in this particular case, Loudoun County is a county in Virginia. In this particular case, there was the chairman of the board of the Loudoun County Board of Supervisors, and she was at home in the evening scrolling through her Facebook account and noticed that someone, a constituent, had commented on a post that she had made, actually not even about county, the board's business. It was actually a post that dealt with the school board, and the school board, that they were their school district's business. And so she had posted something about it, and then one of her constituents commented on it. And if I remember correctly, she didn't like the comment from her constituent, and so she blocked the constituent that evening. And then the next morning, she actually unblocked the person, but the user found out about it and said that her blocking, even for that small period of time, was a violation of their First Amendment right. And so the court held in the Davison v. Loudon case, they agreed that there was a First Amendment violation, but they actually held the chair personally liable. So as opposed to it being a violation that was really a consideration for the public agency, the Board of Supervisors as a whole, it was a personal violation because she had really violated the county's policies by doing the act, by doing the blocking, but she was clearly operating under the color of state law. That was the court's finding. And so because she was operating on her Facebook page, that was clearly a public page, it was identified as her page because she was the chair of the of the Board of Supervisors. She was, I think it had been a campaign page, if I remember correctly, and she had moved her constituents from the campaign focus of the page to it being a place where she was communicating and interacting with her constituents. All of those things were at play that made it really a limited public forum in some way. But even though it was a public forum, which is why she violated their First Amendment rights, according to the court, she was only held personally responsible. And I think it was a nominal damage because she had only blocked the person for a short period of time. It's an interesting question from Dina. Hi, Dina. Could the Davison case apply to a Zoom meeting where you remove a speaker? I think that's interesting. I think it's actually, and Hung Dao could speak to this more because she's more of a Brown Act expert than I am, but I think it's actually directly related to that because even more so because I think Zoom meetings where you're having a public meeting are, they're not just limited public forum or transformed public forums, but right now, especially during quarantine, they are the public forum. And so it would be as if you were removing someone from your in-person meeting. And so usually that's only allowed if the person is disruptive and, there's policies and guidelines as to how you do that. Hung Dao, is that how you would read that answer?
Yeah, I think, when these first line of cases came out, it was very interesting because it was trying to take public forum doctrine and apply it to, these virtual forums. And so I'll kind of get into that a little bit in the next case in Knight v. Trump. But yeah, council meetings in person in City Hall, they're I think a designated public forum, right? And then when they moved on to Zoom, it's still a designated public forum. And there's a couple of notes here about removing people from a meeting or Zoom. It should be a last resort, and it has to regard a person's conduct and not allowing the council to conduct business. When a person is in a designated forum, they have First Amendment rights. And so, this is kind of a preview, but you can't have viewpoint discrimination in a public forum. And so, if you let all the speakers who like, a development project speak, but none of the speakers who don't like a development project, then that would be viewpoint discrimination and that would be allowed. More and more, we've been seeing gadflies and such suing public agencies for removing them from a public meeting, whether it be, on social media and First Amendment on a social media page or in person at City Hall. And so, that's pretty much it, where our recommendation is, if you're going to physically remove someone, it has to be pretty disruptive. Having said that, there have been very disruptive Zoom meetings. I know about people getting Zoom bombed and so on and so forth. So that is, a reality in the Zoom world.
Yeah, but I think that's a great question.
Sorry.
No, I think it's a great question. And I think our next slide transitions you to the Knight case. So there you go, Hung Dao.
Okay, great, thank you. So yeah, this is another social media and First Amendment case. The reason that Christine and I chose these cases is because there's no Ninth Circuit Court case on social media and the First Amendment. Though we have some federal district court cases in California, which Christine will get into in the next slides, we don't have the Ninth Circuit Court case. So we give these slides to you and say the Ninth Circuit, if this came up to them, would probably rely on these cases. The Knight case it involves former President Trump, and so it was in the news for a while. You might have already heard about it, and I think this is a really interesting case because it relates to the former president's Twitter account before he became the president, right? So he established this @real Donald Trump account in March 2009, before he was ever elected. His inauguration was in 2017. And when he became president, he kind of updated the account, and it had, quote unquote, all the trappings of an official state-run account. So he was listed as 45th president of the United States of America, out of Washington, D.C. And as most of us know, he made official policy statements on it, you know, foreign policy, how, you know, who he wanted to hire, who he wanted to fire. And so the plaintiffs were blocked for their critical comments. I want to pause here, and you know, we're on the heels of an election from November 2020, and I suspect that, you know, more than a few city council members or commissioners have transformed their previous election pages into more of, you know, city council pages. You know, they've taken what they used to use as an election page, and now they updated it to say, now I'm a city council member, and they're still sharing information about the city. And so that's kind of how the Trump Twitter account evolved. Next slide, please. And so again, there were folks who started probably trolling the former president and being very critical of actions or comments, right? And so they put up their own comments, and they were blocked from being able to view the page and to be able to, you know, comment and tweet on the page. And so they sued. And in the analysis, the court basically, the Second Circuit Court said that a public forum was created. And so Christine and I have kind of been talking about public forums. There's traditionally kind of three public forums. There's your quintessential one, which is parks and sidewalks, where a person's First Amendment rights are at their height. You know, it's very hard to, you know, clamp down on free speech in those public forums. And then you have non-public forums, which are like military bases, right? Kind of very closed off government, you know, buildings. And then you have these designated or limited public forums where, you know, it's a public forum that's created for a certain amount of a certain type of speech, right? So city council meetings are, I think, designated public forums. They're not just for any speech, right? It's to conduct city business, right? So the Second Circuit Court basically said, yeah, you know, Trump created a public forum, even though it was a Twitter account. And in any public forum, viewpoint discrimination is not permitted. And so one of the arguments that the White House, the former administration, tried to argue was that, you know, it's all government speech. The government has the right to say whatever it wants, and it's not, you know, confined by the First Amendment. Similarly, you know, a city can post videos, post comments, and that is not confined by the First Amendment. And they tried to say that the plaintiffs' replies and responses were government speech, and so it shouldn't be confined by the First Amendment. But the court said, no, we're going to make a distinction between the former president's comments and tweets, and then the plaintiffs' replies and responses, and they have constitutional rights to be able to speak, right? Next slide, please. And so the holding, so the conclusion of the Knight v. Trump case is that the First Amendment doesn't allow a public official who uses social media accounts for all manner of official purposes to exclude persons from an otherwise open online dialogue because they express views with which the official disagrees. You know, again, the summary of that is once a social media account has turned into a type of public forum, then those you know, people who are using it have First Amendment rights. And just because the government may disagree with the comment or the post, that's not enough to be able to take it down or to block someone from that that public forum. And then I'm gonna take a quick look at the chat. I think that Christine is way better at me at monitoring the chat than I am, to see if there's comments. There's a question about, should commissioners, council members have 2 separate accounts? You know, and here's where we put it all together, right? Is that in the previous slides, we said AB 992 is specifically encouraging people, public officials now, to interact with constituents on social media, right? And so on one hand, you have the state legislature trying to push public officials into social media, but then once they do, it's potentially opening this First Amendment forum on their social media page. So the question is, should commissioners and council members have 2 separate accounts? I think, you know, if a council member really wants to speak to constituents on social media, then again, they need to be aware of these restraints, that they cannot, you know, block people or delete comments just because they disagree with them. So it's a viewpoint issue, and to understand that. Certainly, city council members and commissioners could have their own personal pages, and where they, you know, post about their grandkids and about their travels, about their food, their lives. That's not a personal page. What we're really talking about here is when city council members and commissioners use their social media to really talk about public business. Christine, anything that I missed from the chat? I'm taking a look at it, and
No, I just saw a quick comment.
I'm not seeing anything, but
I saw a quick comment from Anna Brown just asking if SCOTUS said that Trump could block, or how did the Supreme Court ultimately rule? But I think you answered that. You have another question. Can you hear me?
Yes, I can hear you.
Okay. Can a Facebook page run by an agency, not by elected officials, hide comments that are malicious? We're going to get to that in a little bit, Sarah, but Hung Dao, do you want to answer that?
Sure. I think it really depends on what the comment is. And you know, a couple of slides after this, we're going to talk about city-run social media pages. It's best to have a policy that says, when can we take off comments, right? And it really is a case-by-case basis. One person who looks at a post might think it's malicious, and another person who looks at it might just say, well, that's a fair criticism of the government, and that should be allowed, right? So I think it really depends. And yes, I think if it's truly malicious, as in, you know, threatening of a person, like hate speech even, then yes, I think that those comments can be hidden. It's best to have a policy that, you know, outlines when a comment can be blocked or deleted. But you really need to look at that comment to make sure, you know, am I just uncomfortable with it because it's critical, or is it truly malicious?
And would it be necessary?
There's another question about, would it?
Go ahead.
Go ahead. Would it be necessary to reflect it was redacted, and why? I think that question goes to document retention, which we do have slides later that talk about document retention. And so let's say that comment was hidden. It would probably be within the city's best interest to keep a copy of that, so that if there was a suit that came up that said, hey, you're violating my First Amendment rights by taking down my comments, it was viewpoint discrimination, the agency, the city had a copy of that post that it took down and said, here's why we took it down. It was threatening, you know, a city council member, or being able to defend it. So yes, I do believe that you'd want a copy of that post that was taken down. Christine, anything I missed? We're good? And then I think Christine has the next slide.
Yes, got it. Okay. With the Garnier case, in this particular case, it involved both Facebook and Twitter blocking. So a combination of both of the kind of cases we talked about before. And in this particular case, the petitioners were filed a lawsuit because two school board members, school board members had blocked them from their Facebook and Twitter accounts for about 3 years. In this instance, both officials had both personal and public Facebook pages, which was something you guys just talked about as Hung Dao was answering that question about electeds maintaining separate Facebook or social media pages. You know, that is so hard and complicated and confusing. You know, I maintain a couple of Facebook pages for some other kind of personal interests and social groups that I'm a part of. And it's really hard to differentiate and separate those things. And so I think sometimes, especially for elected officials, as clerks, you just have to be kind of sensitive to that and understand how complicated that can be for them, and then provide them some advice about what happens, you know, if they make a mistake, if they make one mistake or they post something to the wrong page, or, you know, just be aware of that if you have electeds who are trying to do that, because it can be very complicated, as it was here in the Garnier case. Both officials claimed that they intended kind of a bulletin board format for their website. I'm sorry, for their Facebook page. They in essence wanted it to be like a website, right? They didn't want it to be the interactivity that we talked about is inherent in social media. They wanted it to be one-way constituent communication. But sometimes they did engage in two-way communications, but their intention was definitely to have it be more like a bulletin board. The officials either hid or deleted the plaintiff's comments because they were repetitive. So they felt like if what started to happen was the petitioners would post really large posts over and over, and they would push down anything else that might have been posted either by the officials or by other comments by other people. And so the officials felt like it wasn't having the same kind of effect. And in fact, they were more concerned that it kind of spamming their particular social media accounts so that the other content wasn't able to be seen. And they were able to show evidence at the trial that the officials were less concerned about the content of the post. Like, they weren't really upset that what the comments said. It was just the effect of the comments being so large and so repetitive that it was pushing down anything else that was posted by the officials. In this particular lawsuit, the court found that the plaintiffs had standing, even though they had been unblocked before the trial. So remember, this isn't an issue of, well, I only blocked them for a week or only blocked them for a day. Remember, in the Davidson v. Loudon case, that particular board chair had only blocked them for, like a 12-hour period, less than 24 hours. And so the petitioners can have standing to sue, even if the unblocking is reversed before it goes before the court. In this particular case, they also found that the officials' actions constituted state action due to how the accounts have been used. So they were operating in their kind of government capacity that constituted state action. And then the officials' actions, though, and this is where it was a little bit a little bit of a surprise and a little bit different than some of the other cases we've seen. The officials' actions were based on content neutral rule of decorum. So they had kind of set some standards for how things would happen on their social media pages, and they were content neutral rules. And so the court recognized that, but they felt like they weren't narrowly tailored. And so because of that, it was still a violation of the First Amendment, according to some of the guidelines in the Ward case. And there's been a couple of other recent decisions that we kind of want to point out to make sure you're aware of them. Elected officials blocking a constituent on his Facebook page in this Atwood case. Elected officials blocking a constituent on his Facebook and Twitter accounts were not legislative activities, which meant that the official was not entitled to absolute legislative immunity. So in the 11th Circuit, they had, when they decided this case, they were considering whether or not the official was entitled to some sort of an immunity because of the blocking that they had done on their Facebook and Twitter page. And the court found that you weren't engaging in legislative activities, and therefore the legislative immunity would not apply. Again, this is an 11th Circuit case, not a 12th, not a Ninth Circuit case, but it's something that you should be aware of. Plaintiff prevailed, and court ordered the sheriff to unblock plaintiffs in this Faison case on his official Facebook page by finding the relevant page was a public forum. So again, once they found that in the Faison case that the case was the forum was a public forum, the plaintiff was able to prevail, and the sheriff had to unblock the plaintiffs. I believe in that Faison case, 2020. I think that was a case that recently had to do with some of the recent protests and some of the posts that were going onto the sheriff's page were protesters, and the sheriff had blocked the protesters and was found to have violated their First Amendment rights. And then finally, in the Morgan case is one of the few cases where the court found in favor of the elected official, the governor's use in this instance of his private social media website was personal speech. And so in that instance, the First Amendment did not apply. He was using his social media website, conducting personal speech, not government speech, and so because he was doing that, he was not acting in his state capacity. The First Amendment didn't apply. And so it's very specific and very unique. I don't know. I don't remember what the facts were in Morgan that really allowed for the personal speech finding, but I think it's interesting to note that in some other jurisdictions, there can be factors that would allow an elected official to make comments on their personal social media page without it necessarily being a First Amendment violation. But you have to be particularly careful and make sure you're operating in a private social media account and not a public one. So some key takeaways for our social media in the First Amendment section. Again, there's no Ninth Circuit case yet. It's important to establish rules for public participation that really looks at what's acceptable content. It's often that we get questions from our clients, really concerned about something they want to address or something they want to take down or something that they need to, they want to act on. And our first question is always, do you have a social media policy, right? Because if you establish rules ahead of time for how the public can interact with your social media platform, then how you can respond to particular content is just governed by the policy. So, but if you try to enforce something or try to apply something in the absence of a policy, then it may look arbitrary or it may not look content neutral. So that those kind of rules would include what would be the cost for removal or blocking. How do you contest an action? If you're a member of the public and you feel like you've been improperly removed or improperly blocked, how do you contest an action by the elected or by the public agency, and any other pertinent disclaimers? So there are some things that you can include in your policies or in your rules for public participation that can help give you some guidance when a situation arises. You also want to determine whether the social media platform is a public forum and be consistent. So if you identify, I think Dora has asked if the official wants to close out their account. If they have a public forum or a private forum or anything else, nothing requires them to maintain their social media platform. But if they want to close it out, remember, and it's a public forum, it may trigger other retention issues because those are still possibly public records. And so because they are records that are, government, records, they may want to retain them in accordance with the document retention policy of the agency, but nothing requires them to keep the account. And then you also want to make sure you provide training for employees who are authorized to post on the agency sponsor pages and for the officials who maintain the social media platforms. Don't don't neglect that training, because it ultimately will help them as those issues arise. So Patrice asked the question, can you explain why the 9th Circuit versus 11th Circuit versus 12th Circuit is important? Patrice, every time Hung Dao and I say something about the 9th Circuit, it flashes in my head like I'm not talking to lawyers, but then it flashes right back out. I apologize. So in the federal system, usually in any legal system, all of us are governed by laws of the jurisdiction that we live in. And so when you're talking about state cases or state law, the legislature makes laws for us that govern what we do. The California courts makes decisions that govern what we do. And those decisions are binding on us in the state of California. At a federal level, they have these circuits across the country that govern certain geographic areas. And within California, we're in the 9th Circuit. And so our 9th Circuit cases are the federal appeals cases that bind us on federal matters. And since the First Amendment is a federal matter, usually we look to federal cases to find out how the courts in our area would decide a particular case. And so the fact that there has not been a decision in the 9th Circuit means that there's no decision that really binds us at a federal level within the state of California. And the 9th Circuit covers California, Washington, Oregon, I think, and Hawaii. But there's no case that's been decided in the 9th Circuit that binds what we do, meaning like if you ask me a question and there's been a decision in the 9th Circuit, I can tell you what the law in the 9th Circuit is. In the absence of a case, what I can tell you is what's happened in other circuits, because ultimately that's what the 9th Circuit is going to do, right? The 9th Circuit is going to, when they get the case of first impression, that's a term of art that kind of says they've never decided this before, they're going to see this for the first time. They're going to say, well, how should we decide this? And they'll look to other circuits to see what have other circuits done. The 9th Circuit is historically a very liberal court. And so they're historically probably going to teeter a little bit closer to more liberal circuits in other jurisdictions. Like I think it's the 10th Circuit, I think is the New York court. I don't remember. Hung Dao, maybe you can help me with that. But they'll look to other similarly minded circuits to find out what they've decided, and then they will decide a case of first impression using that technique. Thanks for the question, Patrice. I'm sorry we didn't clarify that before. Is there another question?
Can I interject real quick,
Yes.
Christine?
Yep.
What I would also say is that, the closest the Supreme Court has gotten on this issue is that, it did dismiss the Knight case, and the only reason it dismissed the Knight case, the Knight v. Trump case, that was a few days ago, was because President Trump isn't the president anymore. And so, it means that the Trump case can't be, relied on. And, but I think that Trump case is still a good, example of where the 9th Circuit would go, because the 9th Circuit is more liberal than, other circuits. I think that Christine noted the Kentucky one, and California probably wouldn't follow the Kentucky case. And so when the Supreme Court did take a look at the Knight v. Trump case, Clarence Thomas did write an opinion on it and said, in dismissing the case because the president wasn't the president anymore, he said it highlights the legal difficulty that surrounds digital platforms, namely that applying old doctrines to new digital platforms is rarely straightforward. And he suggested that the U.S. Supreme Court will soon have no choice but to address how our legal doctrines apply to highly concentrated, privately owned information infrastructure, such as digital platforms. And so I think, what we've talked about for a long time now is the Brown Act, the Public Records Act, these type of laws. They're trying to catch up with digital, information sharing and technology and these type of platforms. And I think that as time goes on and evolves, we're going to get decisions out of the Ninth Circuit and the U.S. Supreme Court on this. I think it's a matter of time. But wanted to give that thought on kind of where the U.S. Supreme Court is standing on this position currently.
Let me do the last takeaways. If you decide to use your personal social media platform to conduct public business, right? So if you're an elected official and these are just kind of guidelines as clerks that you should be aware of to kind of talk to your electeds about. If you decide to use your personal social media platform to conduct public business, first and foremost, they should know their city's policies on posting and retention. So this kind of gets them safe if something comes up like the Davidson v. Loudon case, right? They don't want to do anything where they're acting under the color of state law, but violate the policy. And this could help, just a point of reference to get their attention, because remember in the Davidson case, that person was, that particular elected official was held personally liable, not for a lot, obviously, but sometimes these cases can have large damages. So they should know their city's policies on posting or retention. They should also know that a court will consider factors to assess whether their site has been transformed into a limited public forum. And that's, how the public official is referenced, whether the title of the site is, whether it's a government account or a private account. Does the public official invite users to use the page? Whether the public official is transacting agency matters on the site, whether agency employees help them maintain and operate the site, and whether the official uses the site to engage directly with the public. Those are all kind of things the courts might look at to determine whether or not there's been a transformation into a limited public forum. So going back to some of your earlier questions, if they maintain 2 different sites and they one time invite someone to use the page, if they're very quick to undo that and go back to their public site, then they probably have not transformed their site into a limited public forum. It's going to really take into consideration a total of all of these factors. How are we on time? Should I keep going or should I look at some of these questions?
You've got about 30 minutes and there are a few questions that are up.
Let me try and jump on maybe just a few, Christine. Let me see.
There's questions about what if an official wants to close out their account, and if a public official could a public official turn off comments on a post on their own page?
Yeah, so it's so funny. I saw this answer a couple of times before. You guys are either have great city attorneys or BB&K is your city attorney, but you guys have great answers when you say, when you give us the lawyer's answer, it depends or it's complicated, because so much of what even that simple question Christine asked leads us with so many questions, right? So what makes something their own page? Is it really their personal page where they conduct no public business? If that's the case, then they can do whatever they want with the site, right? If they have a private account and they're not posting city issues, and they're not engaged in interacting with the public or transacting agency business, they're not referenced as a public official on their site. If they're just posting on a private account, not posting about city issues, it's not likely that it's been transformed into a public forum. I think Diane's question, though, is if it was originally a campaign account and now posted on that page as mayor, but it doesn't post about city issues. So remember, there's a difference between a campaign site where they're dealing with kind of public speech versus not public speech, sorry, political speech versus public speech. And so the political, I'm not talking, or none of the things Hung Dao and I are talking about have to do with campaign sites. It's more once they become an elected official and they're starting to interact with the public and their constituents, that they begin to operate as a government actor, such that the First Amendment would trigger. So if it was a campaign site and now they're using the campaign site to only do private business, I would still say they're safe, but I would say that you'd have to look at that to really see if some of the factors were triggered. I wouldn't give a direct answer to that without analyzing, because those are dicey transitions you're describing and usually not done very cleanly. Okay. I'm going to keep going then.
There was a question. Oh yeah, there was one question about whether, as a clerk, the clerk should be monitoring elected officials' personal accounts too. You know, the clerks are already overworked and and have a ton of responsibilities. I think probably not, but I think what needs to happen is at least training in this area, right? To be able to say, hey, be aware of this. I mean, when you have at least 5 public officials and their websites and maybe commissioners' websites as well, that gets to be unwieldy. But I think that the public officials need to know about this area of law.
Yeah, I completely agree. I love Maria's no, but yeah, I don't think you guys have time for that either, Ashley, but I would say that training is really important. And I think most of your board trainings, especially now you guys have a lot of new council or new elected officials, just make sure they're trained and have some materials to help give them guidance. But this is a great way to segue to our city-run social media section, because I think it's important to realize what we've been talking about really are the elected officials and their websites, or I'm sorry, their social media sites. Remember though, the social media sites you're personally responsible for as city clerks, right? The city run social media sites are still something that trigger some issues that we should probably be aware of. So we just wanted to offer you some key ideas about city run social media sites that you should be aware of and have in mind, right? You want to make sure your city has a social media policy. Please, please, please. I don't know if we could say this enough. It does not matter if you reach out to us. I saw someone post a model policy, I think, in the chat. However you do it, just get a policy so that you're not operating in the dark, and so your staff has some guidance, and so that you have some assurance, some support, some help if you end up with someone who's challenging an action that you're taking on behalf of the city. Okay. So have a social media policy. Has your city opened a public forum by allowing comments and responses, right? If you start to allow for comments and responses, it really could be interpreted as a public forum. So make sure you understand what you're doing when you open up for comments and responses versus having a bulletin board type of a social media account. We recently saw questions about whether or not your social media accounts can, you can remove posts, take down comments or remove posts if your city official doesn't like those posts. If that happens, if your city official doesn't like the post and asks the city to take down the comments, the city doesn't have any obligation, obviously, to put up any post or to keep up a post. But if you're going to take it down, there has to be a content neutral reason for removing the post. Otherwise, it could be seen as being viewpoint specific. And that's something that could get the city in trouble and seen as violating the First Amendment. Where else? What if a city official asks the city to take down a city post? I think that's a repeat of what we just talked about. And do you have to allow public comments and responses? You don't have to. Again, having a social media policy that directs this and gives the public an idea of what to expect helps you support the decision not to have public comments and responses, but you absolutely don't have to. I'm looking at the questions. How will this interact with the new hybrid meetings legislation, AB 339? If passed, this will require all cities in California to have hybrid meeting models to allow for different forms of public participation, creating different public forums. It will essentially have to have a policy in place before. I'm not familiar with 339. Hung Dao, do you know anything about the wording in 339? I would think though, based on what Michael describes, is that really all you just, I mean, you're having a public forum, even though it's electronic. You're having a public forum that requires you to have a policy in place as to how you're going to be handling it and dealing with it, very much the way that you do your in-person meetings, where you create in real life kind of public forum. Do you know anything else about 339, Hung Down?
No, I'm not. I'm going to look at it right after we get off, but no, I haven't really been clued into that.
Yeah. So our final takeaways on city run are some of the things that I talked about on the previous slide. Also being sure that only trained staff facilitate your city's social media accounts. Again, deleting or blocking posts should be done without viewpoint discrimination and in a content neutral way. And then remember to retain your social media records as you would any other public record, and proactively consider how you will store the content. Which leads us into a quick review of social media and the Public Records Act. Sorry, the chat is starting to distract me a bit. Hold on.
So we are talking a little bit about public records and social media. And, you know, San Jose was really big, you know, a few years ago. But just as a refresher, this is the case that provides that public records can be found on personal accounts and devices, and they can be subject to disclosure under the California Public Records Act. Next slide, please. The San Jose case gave some guidance for searches. It basically provided that, you know, local agencies aren't held to, you know, being able to get the documents, right? Because it's, and I think this was San Jose's argument in the first place, that how do we get these documents? So in response to that, the California Supreme Court said that searches had to be reasonably calculated to locate responsive documents and disclose them that they can find with quote unquote reasonable effort. Next slide, please. And then, you know, the additional guidance from the California Supreme Court was to request that seek public records held in non-governmental accounts. And we're talking about not just kind of Gmail and text messages now, but I would also say social media accounts held by public officials or employees or commissioners. The first step should be to communicate the request to those in question, and they can reasonably rely on those people to search their own personal files, accounts, and devices for responsive material. Next slide, please. And the California Supreme Court also gave certain factors of when a local agency can consider when deciding whether a record is a public or personal record. Again, this is a kind of more challenging find, because these are records on a personal account or social media account. And so we look at the content, the context and purpose, audience and scope. Again, each record is reviewed on a case-by-case basis. Next slide, please. And so, you know, again, this presentation is really trying to put it all together. Now that we're in this world, again, of AB 992, which is allowing public officials inviting public officials, you know, to communicate with constituents and members of the public on social media. Now we have potential Public Records Act ramifications, right? So here's another hypo. A council member who's very active on his personal Facebook account has posted regarding litigation that the city is involved in. Let's assume that the post isn't any privileged information, but it's regarding litigation. A Public Records Act request comes in asking for records related to the litigation. Does the city need to provide a copy of that council member's post to the requester? If you can post in the chat, that would be great. Again, a council member posting about city business on his own personal website or social media account page about city business. A Public Records Act request come in. Do we have to provide a copy of the post to the requester? Okay, next slide, please, Christine. Answer to Hypo 5. Yes. City staff can obtain the post itself by going onto the social media page or ask for the post. It appears that it's subject to disclosure under the PRA, right? And there were a couple of questions that came in earlier about, oh my gosh, now do I have to monitor these social media accounts by these public officials? And what I said before is probably not, right? But you can see the challenge that now is posed to the city clerks about not.
What is that going to look like? I mean, are we going to stagger schedule?
Right. I mean, I think that, I'm not sure if the question pertained to this, but yes, how does that look like? You know, do city clerks now have to go onto each page and have to, be able to mine that data in order to respond? So let's go on to the next slide. And it's another offshoot of the hypo. What if the council member took the post down before the request came in, but city staff is aware of the post? And that's actually happened before, where, sometimes the city is aware of what council members or commissioners are posting about, but sometimes those posts don't stay up. So what is there to do? Does the city still have to provide that documentation? Any thoughts on that? And this is a tough one. If we want to go on to the next answer, Christine. So the issue is, city staff is aware of the post, but now the post has been taken down, and if the post had stayed up, it would probably be responsive. So my best answer to that is, we don't have a copy. The San Jose case didn't say that we as a city or clerks had to, get devices and get account passwords and to be able to get archived, post. But I think at the very least, city staff needs to go to the council member and say, hey, we're kind of aware that there was this post on this issue that's responsive to a request. Can you have a copy of it? Oftentimes when I'm consulting with my clients, I'm looking ahead at litigation and I want to put the city in the best position, right? So I want to be able to go in front of a judge and say, I don't have a copy of the post, but we asked for it. We did what we could to quote unquote reasonably locate documents. I don't know necessarily if that would fly in court, but I mean, that is one of the best things we could do. Christine, do you have any other thoughts on that?
No, I mean, it's going to take us into our next discussion on social media and doc retention, but I will say these are not easy things. And but the one thing you want to do is just make sure you give the right answer, even in the most complicated of situations, like Hung Dao said, so that the record is clear in case you go before a judge.
Right. There's a question of if it's a social media account the public can access, are we obligated to provide the actual post, or can we provide the link to the account site where the post resides? I think there's something in the Public Records Act, Christine, correct me if I'm wrong, that, if it's on the internet, we can just give them the reference to the link. My concern is that, the city might give a reference to the link and that post isn't there anymore. A capture of the post to provide instead of a link.
Yeah, and there's also, I mean, the question is, do you have to befriend the person to see the post? Or, I had a situation before, it was really weird, but the person who wanted the post kept saying that they couldn't access the account. They felt like they were blocked. So the immediate answer, Lucinda, is yes, you can. If you can provide them the link and they can access it, then you've complied with the public records obligations. But the real issue is if they can't access it, you still have your obligation remains until they can get a copy of it. Is there another question? All right, let's go on to the social media and doc retention really quickly, because I want to get you to your super hypo. And unfortunately, a lot about the doc retention isn't, it's just not great news, as with some of the other stuff that we've talked about. So remember, when it comes to cities, unless it's otherwise provided by law, you have an obligation to keep things for a minimum of keep records for a minimum of the 2-year period, right? So, you know, there's other things, court records, records that are required to be kept by statute, records relating to the real property, ordinances, resolutions, or actions by the legislative body. You know, those kind of things you have to keep for longer periods of time. But at the very least, you have a responsibility to keep a record, document, instrument for at least 2 years. And what we come to find is that there's really a question, and there's a difference of opinion, I will say, about whether or not certain instruments, certain writings, certain things within an agency's possession, are they really records such that this particular government code provision applies. So a lot of times there's disputes within the legal profession, within cities. There's a lot of variation where cities are considering, you know, that's not all emails are considered records, such that the 2-year minimum statutory retention period applies. But here, when you're talking about social media and social media posts, assuming you believe that social media are records that need to be retained, there's nothing that requires you to keep them longer than the 2-year period. So these are some of the guidelines that have been provided by the Secretary of State to help an agency consider whether or not an entry on social media is really a record. Does it relate to the social media's does it relate to the agency's mission or policies, right? Does the content show evidence concerning the agency's mission or policies? Is the information unique or available elsewhere? So if you're posting, let's say, the agenda on your social media site when your agenda is available in your agenda center, it's not necessarily unique on the social media site. So that might not be a record that you necessarily have to retain. Does the social media content contain evidence of an official agency business? That was one of the things that really came up in the Trump case, right? And different set of laws governing what's a presidential record. But what was happening was that the elected official in that instance was conducting official agency business, government business through the social media site. Obviously, that would still be a record. It's something that would need to be retained, regardless of where it happens. Does it document a controversial issue? Or does it document a program or project that involves prominent people, places, or an event? Is it a post about a town hall, or is it a stream of a town hall meeting? So these are all the kind of things that might be taken into consideration when you're trying to determine whether the entry on the social media site is a record. So if the social media platform needs to be retained, you want to consider how to retain the record, and not just the record, but its enhancements, its comments, its metadata, all the things associated with the record. Have a plan to export the records from a social media site to some sort of record keeping system. You want to research web crawling tools and software to capture social media entries, or store the original content, including video, somewhere other than the social media site. I think this is one of the reasons why social media accounts become really difficult to process to when you're considering how to retain them. It becomes a difficult process even for the entire organization to think about if you're not using some sort of specific software. It's important not to rely solely on your platform, whether it's Facebook, Twitter, or Zoom, as a way to retain your social media records. It's really important for you not to do that. This is a sure way to get you in some trouble if you're just relying on the social media platform. And so what you might want to consider is whether or not you want to obtain a social media archiving system. The social media archiving system has some pros and cons, right? It's great for capturing the records that you need. It makes sure if there's a social media post that's covered by the archiving system, it makes sure if that post is deleted, it makes sure that the post is still archived and saved in case you need to produce it later because it's still a public record. If there are posts that you need to hide because they are content neutrally, you've determined through a content neutral analysis that there's nothing wrong, that there's nothing wrong with hiding the post, but you hide it. It still leaves it there for you to retrieve and recover later. It gives the agencies all kind of control and access, and it's less, this is probably the biggest point, it's less time consuming than manual archiving, right? So if you're archiving and trying to manage the archiving and the retention of these records in a manual way, I can't even imagine that in some ways. It's incredibly, it's onerous. And so, but these social media archiving systems can be expensive, especially for smaller agencies. Some may charge hosting fees that can add up. And maybe you create greater retention than intended. So you just need to make sure you purge even from the archiving system according to your record retention schedule and policy. All right, so now we have a super hypo. We're going to put all of this together. Hangdao, do you want to start?
Sure. Can you go on to the next slide, Christine? Okay, so we try to put together a super hypo that just addresses the various issues that we talked about here so that you can kind of see how they all relate to each other. And here is the first part of the hypo. So you've got a newly elected council member who has a campaign-related Facebook account, but once he takes office, he updates it. Updates his name to Council Member G, elected November 2020, working hard for residents of the city. He posts lots of photos of his grandchildren, but almost equally as much about city issues. Has he created a public forum? Okay. So I'm getting a lot of comments that he is creating a public forum, and assuming the question came to us, what I would typically do is I would look at the page, and again, we're looking at those factors. How has he or she addressed themselves? And are they an official council person, or are they just Joe on the street, right? Here, I think it'd be tough, though the reference is to himself as a council member. There's this equal number of photos of grandchildren, equal number of city issues, and the courts kind of look at it as a kitchen sink approach. There's no bright line, but let's assume that, yeah, he has created a public forum, and now folks on the social media site have a First Amendment right. Next slide. Okay, so on his social media site, one of his posts is asking residents to apply for vacancies on the Planning Commission. Is that okay? Can he post on his social media site that there are resident vacancies on the Planning Commission? Is that okay? All right, so lots of yeses. Christine, if you can go on to the next. Okay, perfect. That is fine, and that's right under AB 992 that allows public officials to solicit information, to give information on issues of city business. So the next one is another of his posts was taken from the city's Facebook account. So now we're looking at the public account, and he takes one of the posts, he shares it, and he tags another council member. Is that okay? All right. So yes, yes and yes, tagging is just fine. All right, next slide, please.
But isn't there a risk to that we've talked about before, Hung Dao, that you mentioned?
Right. Yeah, yes. I think, yes, we did talk about that, Christine. Good point, where tagging is kind of that difficult place because tagging is kind of like inviting a comment. And so the risk is that council member who is tagged will want to respond, and that would not be okay, right? Risk is response by the tagged person. Perfect. So the next hypo is, if you can go on to the next slide, Christine, is he specifically tags Councilmember H on a post about the city's efforts to bring an In-N-Out burger to the city. Is this okay? And I think for the reasons that we talked about, yes, that is totally fine. Next bullet point is Councilmember H is super enthusiastic about economic development in the city and immediately gives the post a heart emoji. Is that okay? All right. So no emoji response. And that I will tell you that is a confusing thing for some council members. I mean, the council members, I just talked to somebody last week who was surprised about, one, not being able to directly respond, and two, that emojis would be considered a direct response. So in real life, I've had to explain this kind of new thing to council members. So we'll want to kind of educate all council members about this issue. All right, next slide, please.
So if I can just interrupt real quick, we have about 5 minutes left. So
perfect. We are closing down the hypo. Thank you so much for the warning.
Sure.
Okay, so next portion of the hypo is Council Member G is upset when a gadfly comments on one of his posts that she thinks that instead of another burger joint, that the city should be inviting Veggie Grill into the city to diversify the restaurants in the city. He hides her comment. Is this okay? Okay, so I'm getting a lot of no's. And again, let's say, assuming that this is a personal account that has turned into a public one, then this is probably not okay. This would be called viewpoint discrimination. And note that we said he hides her comment. It wasn't deleted, but even the act of kind of hiding is, could be a viewpoint discrimination in terms of that. All right, next slide, please. All right, so the local paper is picking up on this war of fast foods in the city and wants to write an article. The reporter sends the city a public records act request asking for, quote, all communications relating to the kind of restaurants the city is seeking to bring into the city. Are council member G's post responsive? Okay, lots of yeses. Lots of yeses here. And I would agree that it is responsive. Let's go on to the next slide, Christine. So the next slide is the city clerk's office is now aware of council member G's Facebook activity on his personal account and has a question about whether the council member's post should be archived. How is that even possible? Christine, I'm going to give you that slide to get your thoughts on that.
Yeah, I think it's, it's an interesting question. And it really is a question maybe for some of the archiving systems, but I know within the archiving, when you purchase archiving services, maybe if you have a council member who has public posts, maybe or it's clearly a public page, maybe you can allow for the council member's webpage to also be archived as part of your software. Maybe they pay for it separately. It's not that it's impossible, it's just whether or not it is included in the services that may already be provided to the city, or is it a separate service? So if it's a question you should ask of your archiving system. If you don't necessarily have an archiving system and you have a council member who just does one-off kind of personal account. They have one-off posts, then I would do screenshots and come up with a system for them or a place for them to store screenshots of their personal account. So if they have a personal account and they're deciding that they're going to use it kind of as a bulletin board of posting information every now and then make sure that they have the habit of screenshotting it and saving it somewhere every time that they do it. As long as they're consistent, maybe there's a way to set up a good practice for them to do that. We're going to close out with some final thoughts. I think a couple of things is just that, remember, we're still in somewhat murky waters when it comes to social media law and practices. So there's a lot of unresolved issues to still consider. Our knowledge of AB 992 is still new, and our practical understanding will grow over time. Just think it's been 4 years since the San Jose case was decided in March 2017. And look at how much better we are at it, and there's still some questions, but I think all of us have gotten to a place where we really understand it. So give yourself some time with AB 992. Our practical understanding of that will grow over time as well. Recognize that much of the case law involving the First Amendment surrounds elected officials. So just be sure to know how these cases apply to social media pages that are run by the actual public agency. The PRA, remember, still applies to social media. Have a really good course of action. I like this, the best course of action is to have a plan of action. So if you're not going to have an archiving system, have some kind of way where you're going to be able to retain and recover those pages. And then remember that the laws governing the retention of social media records is a little uncertain, but there are best practices. Once you determine that there's a record within the social media account that you want to retain, then retain it the way that you would any of your other records according to the statutes that govern records retention for your particular municipality. And I think that's it.
I think the next slide, right, is a couple slides or information. So we are happy to answer any questions that might arise after the presentation. But we've got a lot of great questions, and thank you so much again for the opportunity to talk during the conference. We appreciate it.
Thank you.
Thank you so much, Christine and Hong Dao, for all that information. I've made sure to save the chat, so definitely did that. And I am going to put the link for the assessment right now up. It is on the Clerks Rock's website as well. So if you just scroll down to this program, you'll be able to see the link for the assessment. And then of course the PowerPoint presentation is available as well. So thank you everyone, and have a great day.
Thank you.